Moving on the 11th order, we have before the Senate Concurrent Resolution 4006. Mr. Secretary.
Senate Concurrent Resolution number 4006, a concurrent resolution to create and enact a new section to Article 3 of the Constitution of North Dakota relating to limited legislative review of initiated measures substantially affecting the state budget, and to amend and reenact Section 8 of Article 3 of the Constitution of North Dakota relating to the effective date of initiated measures.
Senator Hogue.
Mr. President, as the Secretary indicated, Senate Concurrent Resolution 4006 is a proposed constitutional amendment that relates to the initiated measure process. And as the title says, it provides for limited legislative review. Well, what does that mean? Well, what it means is if there is a matter that is to go on the to be voted on by the people, and it has an fiscal impact of more than $50 million, as determined by the state tax commissioner, the director of OMB, and the chairman of legislative management, then that provision would be subject to limited legislative review. And what that limited review would be is that in the first 30 days of our next session, that matter would be given an up or down vote without any amendment or any changes to the measure of any kind. And my reasons for introducing this measure and for amending it, Mr. President, I wanted to provide the Senate with two reasons. And the first one is just a matter of fundamental governance. I hold the belief, Mr. President, that you cannot make budgets at the ballot box. You cannot make sound fiscal decisions about state spending or state using our state resources at the ballot box. And if you look at the way we do that now, I think you'll get a pretty good understanding. As we do it now, Mr. President, we have an appropriations committee from both the House and the Senate. And for the most part, Mr. President, those two committees are comprised of our most senior and experienced legislators, folks who have been in these chambers and served for an awful long period of time. They understand state budgets. They understand the collateral consequences of spending. And I submit that you just cannot do that at the state ballot. And so that's one of the reasons for the proposal. As we've seen in our state, and as what is happening in California, is the initiated measure and spending state resources without going through the legislative process is becoming increasingly popular. And so instead of having debates and referring spending matters to appropriations committees, we have what amounts to 30-second sound bites on each side. And the party that can produce and air the most sophisticated sound bite carries the day in California. Mr. President, that relates to the second reason why I introduced this measure and why I request the Chamber's support. I don't want us to repeat the history of the state of California. Back in the 1990s, Mr. President, the state of California was one of the most prosperous states in the nation. It had surpluses that well exceed what this state has now. In fact, the state of California was among nation states, it was in the top 15 in terms of its GDP. And now, Mr. President, the state of California is $337 billion in debt. It struggles to pay its operational expenses. Just recently, a business newspaper ran an article about how state highway patrolmen cannot use their state-issued credit cards to buy fuel for their vehicles because the state of California is not deemed creditworthy by many convenience stores. So what happened to California, you might ask yourself? Well, what happened is a unending series of initiated measures brought by special interests in the state of California. And those surpluses are gone. This last general election, the state of California had 12 measures on the ballot. They have conflicting measures. They have measures that they can't afford. And the reason that they can't afford them is they never get to have that debate that we have in each of our appropriations committee and that we have in the budget section when we start spending the people's money. What they have, as I said, Mr. President, are 30-second sound bites. And there's been a great deal of commentary about the state of California, Mr. President, and what happens is that it is now the preferred method of getting money from the state that you can't otherwise get through the California Assembly. Because if you have an initiated measure in California, you don't have to compromise. And we all know that appropriations bills, the first thing that has to happen is you compromise. And we know it's easy to compromise on spending decisions because dollars can be moved one way or another to suit the parties on both sides of an issue and on both chambers. But if you're a special interest group, you don't have to do that. And that's one of the downfalls, Mr. President, of the initiated measure process is you don't have to compromise. You don't have to decide whether or not the state can afford your special interest program. You just get your signatures and then get the people to support it, and you get what you want without compromise and without thoughtful legislative review. And so those are the two purposes of this amendment, Mr. President. I'll tell you what the amendment does not do. It does not require additional signatures. It does not require that the signatures come from every county in the state. What it requires is that after the people vote to spend more than $50 million of our resources, we as a legislative assembly engage and decide, can we afford this or can't we afford this? And so that's the limited up or down review. And your committee on Judiciary, Mr. President, recommends a do pass on this measure by a 4-3 vote and asks the Senate to concur therein.
Is there any further discussion? Senator Snyder.
Mr. President, just a question for the carrier. I was wondering if the committee gave any consideration to Article 3, Section 8 of the North Dakota Constitution, which reads in part that a measure provided, or measure approved rather, by the electors may not be repealed or amended by the Legislative Assembly for 7 years from its effective date, except by a 2/3 vote of the members elected to each house. My understanding is that gives us the power by 2/3 majority to overturn the will of the people if absolutely necessary for some fiscal reason or something of that nature. Just wondering if the committee gave that any consideration.
Senator Hogue, are you willing to answer the question?
Yes, Mr. President, and thank you from the senator from Grand Forks. We gave that a lot of consideration, and if the chamber will recall, the old Measure 2, not that was on the last ballot, but the previous ballot, that would have eliminated all property taxes. That carried with it a $1.8 billion price tag. Now, you thought, okay, maybe the legislature could vote to override that, but wait a minute, that was a constitutional amendment. So we would have been stuck with trying to figure out how do we come up with $1.8 billion per biennium, and what do we do? Do we cancel services, cancel government, and raise new taxes? So yeah, we did have that discussion, and the issue is you can't override something by the legislature that's in the Constitution and is embedded there. So we did have that discussion, and that was another reason that supported this measure.
Further discussion, Senator Snyder.
Mr. President, I very much appreciate the straightforward answer. I do believe, though, that without impugning the motivation of the sponsor and bringing this forward, I think we need to be exceptionally careful when we're talking about anything that will impact the people's right to vote and express themselves through an initiated measure. And I'm concerned that if we pass this, people may think that we're smarter than the people that elect us. I know I'm not smarter than the people that elect me. I'm sure I'd get a lot of support for the statement that I'm not smarter than the people that elect me from the members of this body. And I understand also that California has problems, but this isn't California. North Dakotans have good sense. They've used the initiated measure process responsibly. They overwhelmingly rejected Measure 2, which, as the Speaker from Minot recognized, would have a tremendous fiscal impact on our state. And so, to use an old cliche, Mr. President, if it isn't broken, don't fix it. Let's trust the people of North Dakota to do the right thing and reject this resolution.
Further discussion, Senator Triplett.
Well, Mr. President, my comments will track fairly closely with the previous speaker. It just occurred to me as I was listening to the carrier present the bill that that the state of California was invoked multiple times to tell us how we could get ourselves, a state could get itself into a situation where there was a serious problem. And I will say that if I were a member of the California legislature, that I would likely be happy to vote for such a measure as this that has, in a state where there has developed apparently a habit of basically legislating by initiated measure. We have not had an abuse of the system in this state, however, and it occurs to me that the likely motivation for bringing this bill forward was a particular initiated measure which did not get on the ballot for other reasons, and that had a price tag exactly double what is referenced here, a $100 million price tag, which may seem very large to the people of North Dakota still. We're all still adjusting to the new reality in which we find ourselves, where we have more money than we had in the past. I just want to remind the body, Mr. President, that the Resources Trust Fund, which funds our water projects and represents 20% of one part of the oil tax, had for many years produced somewhere between $10 and $14 million per biennium for water development projects in this state. Over the last couple of years, that number has escalated to something above $550 million that we now have available for doing much needed water projects across this state, and sort of in the nick of time, as it were, given the falling off of federal support for such large water projects. And so I think that maybe the number that was suggested here is simply too small for the reality that we find ourselves in. If the number were something, approaching the $1 billion that was referenced as being the price tag, the potential price tag of Measure 2, I would think we all might want to vote for this bill. But $50 million is really not such a significant number in our budgetary process these days. And I think that, as the previous speaker has said, to deny the rights of the citizens of this state their voice for such a small dollar amount, relatively speaking, is really not appropriate, and I would ask for a no vote.
Further discussion, Senator Miller.
Well, Mr. President, I don't have a whole lot more to add, but this bill is creating some strange bedfellows here. I probably would normally stand up and stand in opposition to my good friend from Minot, but I think the problem we're trying to solve here would be better dealt in a manner that would perhaps raise the threshold of electors that are signatures that would be needed to put a petition on the ballot. That's probably a more proper way of doing it, rather than what this bill suggests. And I think the idea is interesting, but we can't take away the people's right to petition and change government. That is our idea of revolution today, and I just don't think that's something that we should in any way try and take away from the people.
Further discussion, Senator Nelson.
Mr. President, you'll see that the vote was 4-3 in committee. So obviously it was a bipartisan vote. When we looked at this, we considered all the things that people have talked about so far. One of the other things we talked about was Section 2, subsection 1, which talked about those three people listed there making the initial determination of whether or not this was a good bill. You're now involving the executive branch into the discussion. During the last election cycle, we had Measure 2 on the ballot. And we had an interim committee that met to figure out what would be the fiscal impact should that pass. And the results were published, and the people listened. And they had that information before the vote, and they defeated the vote based on what they learned. So I don't think this is necessary either, and I was part of that minority group, that 4-3 vote, and we would like you to vote no on this bill.
Further discussion, Senator City.
Mr. President, I was also one of the no votes in committee. That doesn't happen very often, that I disagree with my illustrious chairman. But in this case, I don't think it's appropriate that we put a check on the people's right. And so I just urge you to...
Further discussion, Senator Berry.
Mr. President, I'm not sure, I didn't hear it stated earlier that the required percent of the vote in the body for passage was 40%. It's not a majority vote that is required. It's a 40% threshold. So again, this would be, it was a lower than majority number. I just wanted to make sure the body understood that. That's further down in the draft.
Further discussion, Senator Armstrong.
Mr. President, I would just like to point out as one of the people who voted in favor of this bill that we're not passing anything. We're asking the citizens to vote on this issue. And I think that's an important distinction because dealing with some of these issues, I've talked to a lot of people that don't want us to change this at all. And I get emails about it. I've also talked to a lot of people that think this is a very serious issue and that it's going to get worse in the future. As a body, we're not instituting anything, and I would agree with my friend from Grand Forks. The voters are smart. If we're overreacting, then this will go down on the ballot. If we're not, and maybe some people think that it is an important issue that needs to be addressed, then it will not go down on the ballot. But we're not instituting anything in the chamber. We're putting something on the ballot to ask our citizens to vote on something that at least many of us in this chamber think is an important issue that's worthy of their decision, not ours.
Further discussion, Senator Hogue.
Well, thank you, Mr. President. I did want to echo the comments from the senator from District 36. This measure, if it passes the House, then it goes on the ballot, and that's when we ask the people whether they are willing to voluntarily relinquish a right that they have. But my motivation, Mr. President, for introducing this bill has nothing really to do with this specific measure, but it is, I would say, tied directly to the history of California, because their surpluses were astounding. And there are about 12 states that have the initiated measure process, and there are several more that have the referral process. But their initiated measure process became an industry when they had surpluses. And when they had surpluses, they had lots of special interest groups with lots of great ideas about how to spend the surplus. And that's where we're at right now. And by the time their appetite was whetted, they had measures, conflicting measures going in different directions, and the California Assembly was essentially helpless to do anything about it because it had acquired the momentum that the special interest groups sought, and they continued to introduce measures. And even today, as I said, they're $337 million in debt. They still had 12 measures on the ballot. Mr. President, I believe there's going to come a time when we need to limit the number of items on the ballot because the number of ideas will be unlimited based on the surpluses that we have today. I do ask the chamber to consider the fundamental difference between spending state money and all of the considerations that go into that. We have another constitutional amendment or measure that requires us to have a balanced budget. California doesn't have that. So every dollar that we spend is linked to every other dollar because we have to balance the budget. And so on the past general election, we had a measure that would make animal cruelty go from a misdemeanor to a felony. And I think that's a totally reasonable thing upon which to vote at the ballot box. People can understand the policy behind that. Do you want to impose greater criminal sanctions on people who abuse animals? I think that's easy to understand from the ballot. We had another measure that wanted to ban smoking in public places and places of employment. Again, I think that's a policy issue that you can understand and readily make a good decision on. But when it comes to spending our state resources, I don't think the same is true. And I think that's why, Mr. President, why we have multiple appropriations committees, why we have a budget section, and why we put our most senior people on those committees. Because those decisions are complex. and they do not lend themselves to the ballot box. Mr. President, I've referenced California history, but I'll go back farther than that to constitutional scholars like Madison and Hamilton. They understood the difference between representative government and pure democracy. And if you recall, they imposed on all of us this electoral college because back in their day, there wasn't mass communication like there is, and they didn't trust us to vote for the President of the United States. So even that lingers in our U.S. Constitution because of the complexity that they felt with pure democracy. And Mr. President, I think this is an issue where we as a legislative body need to take a leadership role, and as the senator from District 36 indicated, we need to ask them, are you willing to surrender one of your rights for the benefit of good governance? And I submit the answer should be, Mr. President, yes, we are willing to voluntarily relinquish a right.
Any further discussion? Pursuant to Rule 340, a resolution that proposes a constitutional amendment requires a recorded roll call vote. Hearing no other discussion, the Secretary will open the key on Senate Concurrent Resolution 4006, and the senators will cast their vote. Have all senators voted? Do any senators wish to change their vote? The Secretary will close the key and take the tally. The vote reveals 28 yea, 19 nay, 0 absent, and Senate Concurrent Resolution 4006 is adopted and the title agreed to.